So we're going to get going. This is the legs and regs portion of the session, okay? I'm the legs, he's the regs, or something like that. You've heard from Melman, you heard about what might be in play in Congress. We're going to bring you back up to date, back up to speed with regard to what has transpired, what the law is. We tend to stay not in what might happen, that's Melman, and Bill Sweetnam later is going to zero in on a couple of the HSA and other bills that are in play. So it'll be bill on bills, and that'll be during our TAC panel, which we have immediately after this session. So we'll bring you up to date with regard to everything that's happened since last year at this time, okay? And we actually have two parts of our session, as you'll see. We have the legs and regs update. But we also, time permitting, we'll talk about some of the top compliance issues that Ashley and I see, both for TPAs and employer plan sponsors. And we'll cover a little bit of that now in our session and a little bit more in the TAG panel or TAC panel immediately after. So we have two parts. We're going to get through it quick and cover it. Keep in mind that so much of this is covered by the ECFC Technical Advisory Group. That's a group of attorneys and consultants, mostly attorneys, but a few real people on there too, consultants, who keep you abreast of all developments with the Flex Reporter. Because our conference is so early this year, the Flex Reporter is always at the end of March, so you'll see it in a couple of weeks. But those individuals are the ones that, we work hard to keep you abreast of everything in this area. So let's go ahead and jump right in with the legs and regs session. I'll bring you up to date on health account-based plan developments. We'll talk about regulations in general. And, I'm starting to feel fond of regulations. Now with the new Trump administration, the 10 for 1 rule, you can't have a new reg unless you repeal 10. We might not see that much regulatory action. It might be slow in the regulatory field, but by golly, through executive orders and administrative guidance, I think we'll see a lot of change, and I think Sage picked up on that in his session. I will touch again on MAPIA. So many employers are struggling with MAPIA. There have been a couple of new developments there. We'll then talk about welfare plans, some of the fiduciary and other litigation. Our friends from Groom, Katie Amin and Chris Keller, we'll drill down on a couple of cases, key cases, the J&J case. So we'll tread very lightly on that because we'll cover that in the TAG panel. Then we'll turn it over to Ashley. We'll pick up with issues in prescription drug coverage. We have both litigation issues, state issues, federal preemption issues. A lot happening with regard to HIPAA privacy and security, and notwithstanding what I say with regard to regulations and the kibosh on certain regulations, privacy is a big issue. Security is a big issue. There are laws on the books. There are regulations that are proposed. And even if those regulations don't go through the final, it is a field that you should pay attention to. With that, let's jump right into the account-based plan guidance, okay? We were surprised a little bit at the end of the Biden administration. Well, if we think back to a couple of the sessions here, we frankly were surprised by what the agency officials said when they said, well, we don't know for sure that contraceptives like over-the-counter condoms are an eligible expense. And we all kind of scratched our heads and said, what do you mean? What could be more preventive? Disease, I've got 4 children, mind you, disease-wise and otherwise than contraceptives. And they said, well, we're not for sure that that's okay. Nobody reversed course. I think everybody continued to cover, and we all kind of let out a sigh of relief when IRS Notice 2024-71 came out and confirmed that condoms do qualify as a 213D medical care expense. So whether you're in or out, you're safe now. In or out of the plan, you're safe now.
And at the last minute, they pulled out the bad term, hang on. At the last minute, they carved out the prohibition against condoms in teenage boys' wallet for 3 years because we all know those aren't effective. So, and I probably Never being asked back after that one. So.
And just because your iPhone has a storage case doesn't mean that your iPhone's an eligible expense. I wanted to confirm that. They then followed up with IRS Notice 2024-75. That, of course, picked up on a number of preventive care items. Now, some of these items were added into the ACA mandatory preventive care coverage list, and then were kind of backed out. But on the tax side, this all confirms things like over-the-counter oral contraceptives and condoms are permitted, okay? But there's kind of this quirky old ruling out there that says male sterilization or other male contraceptives are not. I mean, we still have that on the books, and the IRS still thinks that that is not okay, even though, you know, oral over-the-counter contraceptives, condoms are okay, both as 213D and as being preventive care below the HDHP deductible. And then some common sense things: breast cancer screenings other than mammograms, ultrasound, 3D imaging, all of that is okay. Continuous glucose monitors, just like other glucometers, are okay. And that is retroactive clarification of IRS Notice 2019-45. Note here that they limit that to monitors that pierce the skin. Okay, so, you know, if you've got something that reads without piercing the skin, it's not okay, kind of an odd distinction. Insulin and insulin delivery products are okay, and again, that is a retroactive expansion to accommodate the change in the tax code, IRS Section 223C2G. So good guidance from the IRS, some good guidance, good common sense guidance with regard to those items. We also had, and I think we touched on in the August session, the IRS came out with a technical advice memorandum that looked at a choice arrangement. They called it choice, where you could choose between, well, if I'm an employer, I put employer credits out there, you can direct those towards, well, an HSA, an HRA, education, tuition loans, or even an employer-defined contribution plan. And a lot of people said, wow, you know, this is the future of planning. And indeed, that ruling's out there. But when you look at the nitty-gritty, you look at the administrative issues, things like non-discrimination testing, administrative issues, it's a little bit complex, okay? It's not a pre-tax, it's not a salary reduction or 401k type contribution, it's real employer money. So notwithstanding that guidance, that technical advice memorandum, there are a lot of initial interest, a lot of buzz, it kind of, you know, waned, and we've not heard a lot.
I'm curious, have you all seen a fair amount of those programs and arrangements? No?
Takes a fair degree of qualified plan knowledge as well. I mean, I know Ashley and I get questions about it, and we say, yeah, that's a great idea. Let me bring in my colleague Blake, who will talk you out of it. You know, and generally that's what happens. But okay. And then we may recall, and this was like big news last year, the IRS guidance regarding the reimbursement of food and nutrition supplements, where they came out and said, just be really, really careful. You know, just because organic apples are good for you doesn't mean that's an eligible expense. You know, they were worried that there were, you know, certain arrangements that were kind of blowing out of proportion the scope of the IRS 213D eligible medical expense rule. That guidance is still out there. I highlight that, number one, because we learned about it, because the second it came out, they talked about it. We were with the IRS folks at like 3:50. We went on at 4, and they were able to talk about it at 4, number one. And number two, well, now we've got RFK Jr. in there, okay? Are we going to see a change in the paradigm? Do we have somebody that is really, you know, behind nutrition and general medical use of, you know, nutritious items? And yes, that's on the HHS side, but is some of that going to come over into the IRS? Is the IRS maybe going to soften things a bit? It could be a whole new world. Not yet, okay? But let's keep our ears open. This may be an area where, you know, there's room where the IRS might, you know, loosen things up just a little bit. A word about the agency folks. I know we all like to see Kevin Knopf up here, you know, throw chairs back and forth, and, you know, we all have a great session when the IRS agency folks are here. All joking aside, right now, because of the change in administration, they're not allowed to speak, okay? Not that they don't know their stuff, they do. This is common when there's a change in administration. They kind of pull everybody back and say, let's figure out what our song sheet's going to be and then all sing from the same song sheet, okay? That's a little more dramatic this year than it has been in prior years. And in fact, the IRS folks were even pulled back from speaking at the American Bar Association benefits meeting. And so we very much look forward to having them back. And it's important to note that they want to be here. They do like to continue to give guidance and helpful insight, but they cannot. Okay, that's IRS, DOL, HHS, any of the agencies right now. More on HSAs. I think Bill will talk about perhaps the status of the telehealth. There's a bipartisan telehealth bill, and if Bill won't, I will later, or we'll talk together about it. But keep in mind that that telehealth expansion, the provision that basically said you can do telehealth or other remote care below your HDHP deductible and you won't blow up your HSA, that expired, okay? And it's a plan year provision, expired for plan years starting January 1st. And that means if you're still reimbursing telehealth for general medical expenses, you potentially jeopardize your plan. Now, 3 years ago, Congress retroactively reinstated the provision. Maybe they'll do it again. Maybe they won't. We don't have COVID out there. We do have people that are very strongly behind telehealth. We'll just have to see what happens, okay? Now, that doesn't mean you cannot provide telehealth below the deductible, but general telehealth, right? The physician visit, the PA visit. You still have an exception for preventive care. You have an exception for treatment that, and this is from the regs, in the aggregate is not significant in the nature of medical care from a health coach, from a disease manager, or an EAP type relationship or guidance, okay? All of those are okay, but we need to wait and see what Congress does before we open up the floodgate again under our major medical plan to provide below the deductible coverage of general health care. Does that make sense? Okay. I've seen some major medical health plans that have not tightened things up. I think they're hoping that there's a retroactive reenactment, and we always kind of raise the flag and say, hey, we think there's a problem, and then we hear, oh, it's only telehealth, right? It's just telehealth. It's not real medical care. Well, frankly, a lot of medical care now is, well, telehealth. And I really think that, you know, if you're giving general health care through a telehealth arrangement below the deductible, you're raising issues. Figure out a way to charge people for it, even if you charge them and put the money in their HSA. You could do that. That might work, okay? But you cannot do this where it's free or subsidized or reduced cost telehealth below the deductible. Okay.
And charging them has created administrative issues because most telehealth companies only charge a flat amount per service. It might even be a flat amount per employee. So some services might in value exceed what's being charged. And we've never gotten anything definitive from the agencies about, okay, well, if we just charge them the per visit charge that we're getting charged, is that enough to let it be below the deductible in the absence of this exemption? And that's never been clear. But that's certainly one thing to consider. For sure.
And we've had that discussion with Kevin, actually, which is, you know, if we charge something, are you going to challenge us? And he's like, well, you really have to charge the fair market value. And, you know, we kind of puzzled look at him and say, can you figure that out? He's like, no, I can't figure that out. Can you figure it out? No, I can't figure. But if you're not charging anything below the deductible, you really don't have much to argue on. Okay. The final rule for ERISA investment advice fiduciaries. If this were the fall session, I'd say this is like Jason or the son of Freddie, or, you know, it keeps coming back every 4 years with a new ski mask on. And frankly, the agencies tweak things a little bit. Some in the industry would say they really didn't tweak anything at all. They just kind of changed some words here and there. Let me tell you where the agencies went, because there could be the son of Freddie number 5 or 6 or 7. Because Department of Labor feels real strongly this way, not the people at the political appointee level, but the people below who are writing the rules year after year after year. they have decided, well, HSAs are investments, and HSAs, even deposit account HSAs, are subject to these rules. That HSA service providers who receive compensation in connection with investment recommendations would be considered fiduciaries and must fit a potential prohibited transaction. We called that previously the BICE, best interest contract exception. They reintroduced that exception. It's prohibited transaction exemption 2020-02, and they softened it a little bit. They made it a little bit easier to comply with. And that's where the agencies left it in the fall. And then came the court challenges. As before, there were 2 court cases. Both of them found that, well, the fiduciary rule again violated the scope of the agency's authorities, that they could not indeed impose this rule across the board, not just for HSAs, but across the board. So again, there's a stay on enforcement, again, both in district courts in Texas in the Fifth Circuit. Now, Department of Labor just a couple of weeks ago filed a motion. They had a deadline to file an appeal. And typically when there's a stay, the agency, through the Department of Justice, Department of Labor, will file an appeal, and the appeal will say, here are the reasons we think the lower court ruling should be overturned. Fifth Circuit, come get some common sense, let's go. And the Department of Labor filed something that said, due to the recent change in administration, the DOL is now under new leadership. Well, duh. New agency officials are still in the process of onboarding and familiarizing themselves with all of the issues presented by the pending litigation. So it's a 60-day stay sometime, well, shortly after St. Patrick's Day, perhaps on March 20th. We should know whether they actually file an appeal or kind of let it quietly die on the vine, okay? So we'll see where this thing goes. My sense is maybe they won't appeal because there is a new sheriff in town, but we'll just have to see where this goes. So those of you who prepared, perhaps that's good. We'll see this come back in some other iteration. Those of you who kind of held off on preparing, you probably can hold off a little bit more, but in a week or so or 2 weeks, we'll figure out where this is going. Okay. Regulatory update. Lots to talk about here, but mostly in the executive order area. There are a couple of regulations. These were Biden administration regulations that were withdrawn. There was a expansion of coverage for contraceptives where they attacked an exception for moral objection to covering contraceptives. And the proposed rule would have eliminated that moral objection Trump administration exception, and that proposed rule was withdrawn. So it's kind of status quo back to that Trump administration era regulation. There was also another regulation that would have extended required coverage for preventive services. This is the one where he said might require that you cover over-the-counter contraceptives in a major medical plan without a prescription or without imposing cost sharing. Again, that one was withdrawn on January 15th, so they're gone. Okay, and these are major medical regs. They're impacting, the major medical plans, but kind of indirectly impacts us because if it was required to be covered under the major medical plan, then it would not be one of those expenses that you send through your FSA, HRA, HSA, what have you. Now, as is typical or often the case when there's a change in administration, there's a regulatory freeze. And the regulatory freeze on all regulations that were subject to review was issued by the White House. And basically they said, look, any regulation that was, in the pipeline prior to January 20th, 25 would not go into effect until the new agency head reviewed it, decided whether they wanted to make that go through. And so again, February 20th, March 20th, we might see some regulations that they have decided those are too intrusive, those are too difficult. Agency, you kind of were out in front of your skis. We're going to pull that back. What ones are subject to that? Ashley will talk a little bit about the HIPAA proposed security rule. Very extensive requirements, further requirements imposed on health plans, including health FSAs and HRAs. That one might get pulled back, okay? It's subject to the freeze. Will it be pulled back forever, put the kibosh on? We don't know. There's an aspect of the final mental health parity regs I'll talk about in just a bit, not the whole thing, but an aspect that might be pulled back as well. I will note that both of those issues are very important issues, and I don't think it's a matter of whether the regulators will regulate, but whether they kind of made it too hard, too difficult, and whether they'll kind of loosen things up a little bit. The Congressional Review Act. Congress can negate certain administrative actions taken close to the start of a new Congress. How close? Well, 60 days, and that's not 60 calendar days, that's not 60 school days, that's not even 60 in-office days, that's 60 in Congress days. And the Congressional Review Service did a study, and it said it's anything that, any regulation that was pushed out on or after August 1st of 2024. That's like half a year. But, you know, anything on or after that date could be subject to the Congressional Review Act. The Congressional Review Act would allow Congress to pull it back just by a simple majority if they didn't like the particular rule. What could be subject to that? Well, it's possible that the MAPIA final rule that came out, there was a big rule I'll talk about in a minute, it's within that time frame. Will Congress pull it back? They might just say it's too difficult, go back agencies and try again. But that's the primary one. If you look at the others on this list, everything from the Affordable Care Act non-discrimination rule, 1557, to the HIPAA privacy and reproductive health care rule, all of those were before that August 1st definition, August 1st deadline. I wanted to talk just for a minute on the STLDI independent, non-coordinated, accepted benefits level funded arrangements. That was a regulation that would have substantially changed the way that ancillary coverages, things like cancer insurance, $100 a day hospital insurance, would be taxed in whether or not they could be offered. That proposed rule, when it became final in June of last year, June of 24, pulled back all of those significant changes and only had a notice requirement. So there were significant changes in the pipeline, and because of reconsideration by the agency, they actually loosened up and only imposed a notice requirement.
And we probably should mention the notice requirement has been subject to, is it the fifth, sir? No.
Yeah, I got it coming up with litigation challenges.
So even if it makes sleep.
Even if the reg makes it through the Congressional Review Act, the Regulatory Freeze Act, an administration that doesn't like the reg and then says we're going to repeal it and you can't pass a new one unless we take 10 more back, there are litigation challenges out there. The Mental Health Parity Rule Act, Mental Health Parity Rule Reg that I'll talk about in just a minute, is right now being challenged by the ERISA Industry Committee. That's a large employer association based on basically exceeding the authority that they've got. It was too difficult, too much, beyond the scope of what was required by the statute. There's a challenge to some of the non-discrimination regs under the ACA 1557. Those are the regs that the Biden administration used to impose requirements related to sex discrimination, gender identity issues, and certain treatments, what have you. And there are several cases that are challenging that, both with a nationwide injunction and then cases in Texas and Montana that have a state-based injunction. The HIPAA privacy and reproductive health care rule, that's the rule that says that if you have any information relating to reproductive health care, you basically can't share it, even though it might otherwise be okay under HIPAA. It was a new rule that said it's super protected. That was challenged in Tennessee v. HHS, and the court issued an order holding, at least temporarily, holding briefing in abeyance, so there's a challenge outstanding there. And as I mentioned, there are two federal district court cases that have placed a stay on the investment advice fiduciary rule. And finally, Ashley, where you were going, there are court cases that have said that the notice requirement for those short-term limited duration or independent non-coordinated, let's just say $100 a day cancer and other coverages, that new notice requirement right now is stayed as well. There's a separate challenge that is looking at the short-term limited duration insurance restrictions. So there's a lot going on. I mean, you've got to find your issue. You've got to zero in on that issue. You've got to see what the regs have done, what the court has done. And if that's not confusing enough, now we've got executive orders, okay? Some of these might be helpful. One of the big issues that
can I just mention one thing? Because
Yep.
on the
litigation, go ahead.
well, on the notice, we've debated internally and reached out to our policy folks, and Bill, maybe you can address this later, but I think there's some question as to the scope of that decision regarding that notice and whether it extends outside of that district or circuit in which that case is in. And so, and keep in mind that rule does extend to employers who offer these policies to their employees if they're conducting the enrollment. And so the notice would actually have to be on the employer's side of the enrollment. And we're not 100% sure how far that, right? I mean, I don't remember who we talked to about that. But.
It's unclear whether it's a nationwide
Yeah.
stay or just for the Eastern District of Texas. But I think the fact of the matter is that the HHS, who is charged with enforcing that notice requirement, in all likelihood may choose not to enforce it nationwide.
But keep in mind, it's not just for the carriers and their policies, it's for the employers if they're conducting enrollment. Almost all of our clients do, and I suspect yours do as well.
Transparency. Now, the Trump 1 administration, transparency was a big issue. And by the way, transparency is our friend, right? What better facilitates consumer-directed health care than transparency in pricing, charges, rating, what have you. And so the new executive order is actually helpful. It's unrealistic, okay? But it says, look, that old executive order, the one from 2019, we're serious about this. We think that this should go forward. And that's okay, yeah, let's push it. That's a good policy. And within 90 days of the date of this executive order, the secretaries must take action to ensure that there's the required disclosure of actual prices, not just estimates. Really, in 90 days, they're going to have the physicians giving actual price amounts after coverage? I mean, some of this is aspirational, and we think it's good. It's going to be, I think, a heavy lift, but that's a huge issue, which is helpful for us. And we'll have to see how the secretaries, Department of Labor, HHS, actually effectuate this most recent executive order. They might go back to the first regulation and say, yeah, we're serious, you got to follow the regulation now. And there was a lot of trouble in getting that across the board. Other executive orders, there's executive orders in favor of IVF. One of the big issues under 213 is whether or not an expense paid for IVF, not for your employee or your employee's tax dependent, but the non-tax dependent donor or the non-tax dependent recipient, whether their expenses would be an eligible medical expense. And the IRS said no, okay? And we think that, maybe under this executive order, they might revisit that, okay? That would be a good thing. That would be helpful. An executive order with regard to federal dollars for abortion coverage under the Hyde Amendment, there should not be. And so they reiterated that. Executive orders with regard to all sorts of aspects of gender ideology, extremism, and restoring biological truth. This is the executive order title, okay? I'm not trying to project moral, one way or the other. But a number of executive orders relating to gender identity and treatment of minors and what have you. So we shall see where these go. We note that there are a number of court challenges to these orders. In fact, in some cases, some injunctions have been issued against the orders. This is going to be a very litigious area. It's going to take years for the dust to settle, I think, with regard to that issue or those issues. Alston and Bird, we have an executive order action and proclamation task force. They keep a chart. If there are particular orders that are of particular interest to you, this link is a live link, and I think after the session that Crystal will make it available for folks to download and use, but it's on our website. It's not something Ashley and I create. Our federal relations people create it and keep it up to date. So that might be an area to keep up with various executive orders as you track and look.
Hey, and as we go into this next session, you know, most of this deals, mental health parity deals, not next session, but next topic. Most of this deals with major medical plans, and certainly that's where the greatest impact is. But it actually can creep into our consumer-driven healthcare world when you start offering HRAs that are very specific expense-oriented. For example, just this morning I was asked, well, hey, can we provide $1,200 a year just to reimburse certain medical services and nothing else? Or you might have a situation where it's some amount for medical, I've been asked this as well, and a lower amount maybe for mental health or substance use. And those can create mental health parity issues. So certainly an issue to think about as we talk through this and your clients start to ask questions about HRA reimbursements and how those can be limited or more narrow.
Or just by way of example, I mean, you know, if the agency said, well, yeah, under 213D, it would be okay to reimburse an IVF expense of a non-tax dependent. And so you put in an HRA to cover those expenses. And we have had clients that have HRAs for IVF of the employee, where the employee's tax dependent, but maybe they go broader. That would violate mental health parity because you're providing an extra benefit that may likely, well, in most likelihood is not provided on the mental health side. This is a huge issue, and I mentioned it's a huge issue, and again, you know, kind of caveat it, as Ashley said, it's a major medical plan issue, but it's one that all of your employer plan sponsor clients should be aware of, okay, barring some drastic action under the Congressional Review Act or by the Trump administration to pull it back. Essentially, the final reg, and again, subject to attack or appeal, or subject to that court challenge by the ERISA Industry Association, everyone is required to have a comparative analysis. And the agencies view this as a 2021 CAA 2021 requirement. It's not new. It's been there. But what they have done is they've said, look, there's some new requirements under the final reg that we're going to impose on the employer plan sponsor. For example, the employer plan sponsor has to have a fiduciary certify that the analysis has been done, that they've reviewed it, that they think it's hunky-dory, that it works. Okay, that's a legal term for, yeah, it's all there. None of these analyses are there. Okay, we know companies that do the analysis. It's very complicated. Even the ones that do it best still have some gray areas. It's just a very complicated reg and rule and very difficult to do. But now employers are required to certify as a fiduciary that the analysis has been done, that it's in compliance, or if it's not in compliance, what's out of compliance and what will they do to fix it. This is something we've seen the Department of Labor both complain to Congress about. The plans aren't complying. And the plans aren't complying because the plans can't figure it out, or it costs too much, or the expertise is not there, or the timing is too difficult. But not only are Department of Labor complaining to Congress, asking for additional authority out there, but it is an area where, you know, we expect the agency, until it's pulled back, until something has changed, the agency to continue to push. And we've seen it in agency investigations. There are 6 EBSA, that's the Employee Benefits Security Administration priority areas that we have found and they've acknowledged are the vast majority of their investigation focus. Prior authorization requirements for in-network and out-of-network inpatient services is more draconian for mental health care than it is for medical surgical. Concurrent care review, both in-network and out-of-network. Standards for provider admission to participate in a network, including reimbursement rates. Department of Labor is upset that there are not as many mental health providers as there are medical providers. Now, you know, in some cases, they kind of overlook the fact that a lot of general medical practitioners provide basic mental health services. Some people obtain mental health services, at least basic services, through the EAP. But they're surprised, and they, to some extent, are requiring that plans have equally strong networks in the mental health care side as they do on the medical physical side as well. Now, I'll tell you, just, trying to find a child psychiatrist, child psychologist in the Atlanta area, whether in network or out of network, that will take appointments, they're not there, okay? They're there, or there's such a demand that we can't get the appointments. Should we really be blaming the plan for this? Is the employer really at fault because they can't get enough? Or maybe we just need more providers out there. Maybe there's a different solution. And that's why we say, under the Congressional Review Act, everybody believes, I think, without exception, that there should be parity, that there should be equality with regard to mental health and non-mental health medical surgical care. The question is how, and whether or not the regulations they've got in place are too draconian. Out-of-network reimbursement rates are looking at adequacy standards for mental health substance use disorder provider networks, like if you require a PhD for a psychologist but not for a medical doctor. I mean, we're to some extent not really comparing apples and apples, but these are issues that they're focused on. Just a couple of words in the fiduciary and litigation area. There is the big case, the J&J case, where employers are being sued based upon the rates that medical providers are paid, okay? Typically in the prescription drug area, but across the board. And I'm going to leave that discussion for Chris and Katie in our tax session. They'll touch on that. But it's a huge issue. Employers really need to take steps to make sure that they document their RFP process, their analysis, and choosing their service provider. We've got some rudimentary suggestions here. Have a committee, send out an RFP. This is not just a major medical plan issue. Okay, if an employer is having, selecting an FSA provider, an HRA provider, an HSA provider, an HSA investment option, and that is not in the best interest of the employee plan participants. Maybe the fees are much higher than market. The employer could be sued under a fiduciary type lawsuit, and it's very important for the employer to have a process, okay? Let's issue the RFP, let's do a comparison. If we pick provider number 1 for HSA investments instead of provider number 2, why is that? If the rates are higher, is there better service? What are the factors that we've looked at? Look at it, analyze it, document it, keep it, knowing that someday there may be a lawsuit, perhaps in connection with the last 2 weeks stock market decline, right? Perhaps people will say, gosh, you picked that HSA investment provider based upon, reputation, and look, they're the worst of the market. And this is something we've seen in the 401k arena for years, and there are a whole bunch of theories and cases that deal with, if your process is sound, even a good fiduciary might make a bad decision, but you've got to have a sound process. I'm going to leave that for Katie and Chris to talk about. Last topic I'll touch on, and then Ashley, I'll turn it over to you. Wellness program litigation. There are significant rules that we've had since 2014 with regard to the Affordable Care Act and wellness programs. And there's certain requirements that you've got to satisfy if that wellness program impacts health or health standard. And what we're seeing now is there are plaintiff firms that look at wellness programs, smoking cessation programs, and they say that the plan did not dot the I's, cross the T's. Maybe they're required to have a reasonable alternative standard. If you can't quit smoking, that's fine. Attend a smoking cessation class. But you've got to give the credit retroactively if they attend the smoking cessation class. And when you're not dotting the I's, crossing the T's, following the regs, working with counsel, if you have a wellness program, you may be subject to one of these lawsuits. We've seen quite a few out there.
Yeah, let me hit on that just real quickly, because I know a lot of you probably talk with your clients about wellness programs and smoking cessation programs. And what we typically see are programs that say at annual enrollment you certify your tobacco use, and if you certify that you use tobacco products, then we're going to charge you a higher premium. But if you complete the tobacco cessation program, and you can sit in the back of the program or during the class and puff away or dip or whatever the case may be, but if you complete it by a particular date, we'll retroactively reimburse those surcharges. If you do it after that date, it'll be a prospective drop in that surcharge, but we're not going to retroactively reimburse. And the rules are just not clear about, what dates are okay. The agencies have come out and said you just need to give them a reasonable period of time. And so a lot of these, there's 20 plus lawsuits, and a lot of these suits are giving folks until June, the end of June, end of July, in order to complete that program. That's not sufficient according to plaintiffs, that if you completed in November, you've used tobacco the entire year and completely undercut what the purpose of the program is, you still have to give a retroactive premium reduction. And so there's a lot of wrangling going on right now. We're actually working on 2 of these cases. I'm working on one personally. And there's a lot of wrangling about the statutory language, regulatory language. But if you're talking with clients about that, one point to consider is how long are you going to give them to complete that program? So with that, before I get into this, I have to share this. Since I've already stuck my foot in my mouth, it started making me think about probably the biggest gaffe I've ever had, and it's here at ECFC. And I see a lot of new faces in here, so I've got to share this. This is probably 22, 23 years ago. It was my very first ECFC conference. I was a nervous wreck. There were probably 400 faces in the crowd. And I had this joke that I was going to lead off with that I thought would be pretty funny. And the joke kind of went something like this. What an honor to be speaking at ECFC. What a great organization. I mean, really the work that you do is incredible. And I'm so honored, and what a privilege. And it's so great. I told my wife, and I thought it might lead to a romantic evening. That's not funny, but it's also not what I said. What I said was, what an honor, what a privilege to be speaking at ECFC, and I hope it leads to a romantic evening. And really, up until about 3 years ago, that was pretty standard for a few of you, I don't see them in here, to come up after the session and give me their hotel room key as a joke, like, oh, hey.
Yeah, I was checking our E&O coverage.
He was green.
Our termination for cause provision for attorneys, but there's a few difficult moments there.
So today was not a huge gaffe. That one was a big one. Okay, so let me talk a little bit about the prescription drug program issues that are going on. I'm not going to get into the details about some of these programs. They're copay maximizers, alternative funding arrangements, copay accumulators. Here's the deal, and here's how it affects us in this room and the work that we do. These programs give savings to a plan and frankly to participants, usually with specialty drugs. They leverage manufacturer assistance. So manufacturer provides assistance for a particular drug. I've been prescribed that drug. They will, in many cases, change my copay to match that assistance. I pay nothing, and then the plan is also not paying anything. But regardless, I, as a participant, am getting assistance. Well, the IRS has indicated that that kind of assistance basically can't be applied towards the deductible, or it would disqualify you. That it's basically, because it's assistance that's given to me as an individual, I'm actually paying that, so it can't be applied towards the deductible. And there was some conflict initially on with the major medical plan rules, and what HHS and the agencies ultimately ended up saying is, well, they had an original rule that said, look, you have to apply it towards the deductible, or towards the out-of-pocket max, not the deductible, but the out-of-pocket max, unless there's a generic equivalent for that drug, but then realized, hey, this is going to really create havoc. So we're not going to enforce that rule, and you do not have to apply manufacturer assistance towards the out-of-pocket max, which obviously would include the deductible. Hey, great for HSAs, not a problem. Fast forward a little bit, lawsuit comes up and says, no, that needs to be counted towards cost share, the out-of-pocket max. And so right now, we're back at a rule where it has to be applied towards, under the court case, has to be applied towards the out-of-pocket max, unless there's a generic equivalent. Now, HHS nor the IRS appears to be enforcing this. There's some legal wrangling going on, but this is the thing to watch for us, especially those of us who administer HSAs or advise clients on HSAs, and to watch this litigation to see where it goes, because at some point, if those amounts have to be applied towards the out-of-pocket max, you either have to find a way to not also apply it to the deductible, or you just have to carve folks out of those programs. So, did you want to comment on that?
Well, I think some on our board have said it's an existential threat to HSAs, and it is something that groups are looking to fight against and challenge. Keep in mind that the current rule presumably only applies to fully insured plans under HHS. It's got to count.
Yeah.
May not apply to self-funded plans. And that also there is the kind of the out clause if the drug is a drug that also has a generic equivalent. So, I think it's an area where a literal reading of the rule leads to a very bad result for individuals. Individuals have very high-cost drugs where the cost of the drug is paid for by the drug manufacturer. And why not give credit? If my dad pays for my deductible, I still get credit, under the deductible, and it doesn't blow up the HSA. Maybe my dad is Mr. Pfizer, okay, and maybe that should be okay as well. Some of those discussions are being had with HHS and IRS. It would be great if they would find a way to say that, applying it towards the deductible is not bad in the case of an HSA, because we're going to treat it not as a plan benefit, but as somebody else paying it. But it is something I think we're waiting for the HHS rule that comes out soon for 2026. Is it the 2026 rule? To see if they've changed their position on it. But we'll have to see.
Also, we know right now, obviously, PBMs are a focal point of the federal government, even state government. We know the FTC has filed an administrative complaint against, I can't remember which PB, it's really the big ones, with CVS and ESI, yeah. And I love when litigators like to get flowery with their wording in their complaints, but they allege that it created a perverse drug rebate system that prioritizes high rebates from drug manufacturers, leading to artificially inflated insulin prices. Hate those perverse drug rebate systems, don't you guys? Anyway.
It's a PDR under a PBM.
Yeah. We'll see how that turns out. There's also a lot of wrangling about the state PBM laws, and this has progressed. We started with Arkansas's law, and Arkansas's state PBM law really focused more on the relationship between the PBMs and the pharmacies, and addressed the terms of the agreements between those two entities. Did not really leak into plan design so much. Yeah, it may have affected some of the contractual arrangements between the PBM and the plan sponsor, but the gist of the law was really focused more on that relationship and the pricing agreements between those two entities. That went all the way to Supreme Court. Supreme Court said those provisions are not preempted by ERISA, and so PBMs in Arkansas who administer group health plans have to comply. Then we moved into, and there were others. Tennessee has a law, Florida has a law, but fast forward, Oklahoma also has a law, and it went a little further than Arkansas's law did. And what we're finding is these state legislators are saying, well, Supreme Court said the law in Arkansas is not preempted. Let's just regulate everything a PBM does, and we're seeing that in some of the states. It's pretty extensive. And so the Oklahoma law has made it all the way to the 10th Circuit. The 10th Circuit has said, yes, there are aspects of Oklahoma's law that is preempted by ERISA. Still waiting on a Supreme Court decision on that. We'll see how this turns out. The point of all this is to say there are a number of states, again, Florida, Tennessee, obviously we have Arkansas, we have Oklahoma, I'm trying to think who else. And a lot of these states are getting into plan design. So, for example, a lot of these states would not allow a contract between an employer and a PBM to carve out a specialty drug network. In other words, you have to allow participants to obtain prescription drugs at any network in the plan if they provide those. And a lot of our clients have discrete specialty drug networks. And obviously that's getting into plan design. Some will require that copays or that rebates be applied at the point of sale when a participant's purchasing drugs. So it goes very far. But they also require plan sponsors to notify the state of certain things. So Florida right now has a law that says, hey, you have to provide notice to us that your arrangement with the PBM is in compliance. And Arkansas now has a law that says that. Now the question is, okay, is this preempted? And you may get questions from your clients about, do we have to do this? I think there's a very good argument that they are preempted under not the Arkansas decision, but under Gobal. Is that how you say that? That's how I say it. Being from the South, you never know whether the word you're using is correct or not. And Chris Keller's back there loving it. It's probably wrong, I'm sure. Oh, well, that's certainly the fancier way to say it for sure. So, and do you have to do the hand up too when you do that? Okay. Okay, everybody, you want to do this with me? It's go by. Go by. Okay. So I think there's a very good argument that they are preempted. What you have to talk to clients about if you're having this conversation with them is, well, do you want to, does your plan actually comply? Are you actually doing what it is they're wanting you to report on? And if so, is the juice worth the squeeze to try and fight preemption on this? It's an interesting conversation because sometimes even if you think it is preempted, certainly the states do not, and that may be a battle that they have to take on.
And, there are so few areas where you want federal regulation, but maybe some people would like it here just so we have a uniform regulator, and all the states are not doing their own thing.
And certainly there have been some proposed federal laws, but nothing that's made it into law. Let me move into HIPAA. John talked a little bit about reproductive rights. And there's a lot that's come out. We have obviously the reproductive rights rule that required that if you receive a request for reproductive rights information from a state agency or law enforcement seeking information on someone who may have obtained reproductive rights services in a state where that's illegal but gone to a state where it's legal, that was really, I think, the focal point of this, then you're not permitted to do it, and there are certain other requirements you have to take when there are other requests not for that purpose. Those rules do apply to you as business associates, and you would need to update your policies and procedures and train to make sure that if you get those requests, you need to do that. We also have the proposed security rule, which is...
But as a practical matter, how often do you as an FSA or HRA administrator get those? Very rarely. But you've got to have it in your rules. You got to know when it comes up.
Well, that's what I was going to get to.
And if... And if it's a request by the participant, it's not subject to this rule, it's somebody else. And so, it is something we have to embed in the policy, but administratively, it's not a big change.
And there's I was going to say all that. But there's an onerous proposed security rule as well. But I really want to take this opportunity to underscore a couple of things that we find quite often. I know everyone in here knows this, but a lot of your clients don't. The HIPAA privacy rules and security rules actually apply to health FSAs and HRAs. I cannot tell you how many times we've had a discussion with a client, and I'll say, it'll be a new client, and we'll say, hey, let's see your HIPAA policies and procedures and your risk assessment and for your health FSA, and like, oh, we don't have that, it doesn't apply. And that's when we have this little alarm that we hit on the thing, and the lights go off, and we hit that. No, we don't do that. But it does apply, and this is a great opportunity for you to reach out to your clients. Remind them that it does, and to the extent that they're not doing what they need to do, it's a good time to get that done. And I would point out the risk assessment is also not only important for your plan sponsors in their capacity as plan sponsors of a group health plan, but also for you as business associates. And it is not uncommon for OCR and in an investigation to ask a third-party administrator for that risk assessment. So be sure you have that, and that'll certainly become a focal point.
We get questions sometimes like, well, as an employer, can I just make the TPA responsible as my HIPAA privacy official for the FSA? And the answer is yes. Will you find an FSA administrator that takes that on? Probably not. They may not want to, but that is an option.
Yeah, so with fully insured plans, you have the opportunity as a plan sponsor to shift a lot of that responsibility to the insurance carrier, because the insurance carrier in that capacity is a covered entity subject directly to those rules. As a self-funded plan sponsor, like a health FSA or an HRA, you can, by contract, delegate that to you all, or y'all, as John and I would say.
All y'all.
Chris would say, you all.
Goodbye.
But, yeah. But it's still on the plan sponsor to ensure that its plan complies. And here's the response we normally get. Well, we don't receive any PHI. Our third-party administrators have all the PHI. But as a self-funded plan sponsor, can you really be in a position to never have or lock yourself out of access to PHI? I don't think so. I mean, you have to monitor the plan, manage the plan. Oftentimes you might receive information from a participant, and so I don't think that's possible. And so you still have to do these things on the plan sponsor side to ensure that, when you do have that PHI, it complies.
And this comes up in some weird ways, like, for example, the Change Healthcare breach. Some FSA administrators are now getting notices that their data may have been impacted by, Change Healthcare or a breach or what have you, or a breach at the employer plan sponsor. So, the worst policy is no policy. That is the law. HIPAA does apply. You can't avoid it. Make sure there's some documentation somewhere. It can be pretty, HIPAA scalable. It can be pretty basic, but HIPAA does apply to FSAs, HRAs.
Yeah. We did last year receive some guidance dealing with online tracking technologies. Fortunately, this was vacated by the district court in Texas, but had it gone into effect, it would have been extremely challenging to implement, I think, because really this was dealing with, I go to a website and that's a hit, and that may or may not have been PHI depending on the intent that I was there, that I was going online, and maybe the services that you provide. It was really going to be an interesting, especially for those of us in this field, going to be interesting of not only when it applied, but how we, hold on, John and I want to look smart for this picture. Okay. And I'm not going to go into detail on the new proposed HIPAA security rule. We really don't know at this point the extent to which it'll go into effect, if at all. It's relatively significant, and again, would impact health FSAs and HRAs.
And when you read through this, there's some ridiculous provisions. I mean, you have to have a data recovery plan that, restores critical data within 72 hours. There's some other provisions where they have a finite time period. I think one was like a few hours where you have to respond to a security risk. This rule may be subject to it's subject to the reg freeze. It may get pulled back, may get changed. But there definitely will be something that follows through in this area. And also keep in mind, even without this rule, there is currently a HIPAA security requirement that applies both to employer plans and to plan service providers.
Yeah, and one element of this rule is for business associates to certify every 12 months that you have appropriate technical safeguards in place based on these rules. So it will be far-reaching and hit all of us in this room, and as well as our clients. Okay. We also have updates to EBSA cybersecurity guidance. There's no statute or reg in this regard, and I'd be interested what Katie and Chris are seeing as well, and you all, but in almost every DOL investigation that I've been part of, that I've advised clients on, totally unrelated to cybersecurity, they kind of squeeze that request in at some point during the investigation. We're gonna look at how you handle unclaimed property checks, and by the way, would you provide us a copy of your cybersecurity guidelines? So my question for you
and
is...
this is DOL.
Yeah.
So we've got HHS that enforces HIPAA security, HIPAA privacy.
Yeah, this is...
Then we've got Department of Labor that's out there saying every health plan, FSA, HRA included, major medical plan, you've got to have cybersecurity provisions in place, and we're going to tag you as Department of Labor if you don't.
So my question for you is, and don't raise your hand and don't answer, this is rhetorical, do you have cybersecurity guidelines? And have you reached out to your clients to see if they have cybersecurity guidelines? Something to think about and not answer or raise your hand on. Okay. How do you want to do this?
So, Ashley, go ahead just a little bit about the wellness program scheme, what have you. Basically, this is the arrangement that says, you can reduce your pay and then reimburse yourself on a pre-tax basis and you can do it
with no expense.
with no expense,
Right.
in increments of $500, $1,000, $1,500, doesn't matter. You get it all back. And by the way, you get it back automatically if you do a simple wellness thing, like maybe, read a wellness newsletter. The IRS issued another Chief Advisory Memorandum, 2023-23006. Read it, okay? This undercuts and knocks out most of the programs that we've seen. Now that Kevin Knopf worked very hard on this and wants to make sure that people are not out there, basically laundering wages as tax-free health reimbursements.
Yeah, the key from all of these is under the code, it is not possible to take an employee, first and foremost, not possible to take an employee's pre-tax salary reduction and then give it back to the employee without a corresponding expense. End of story.
There's a pot of gold at the end of every one.
Oh, God. See, I tell him all the time, there's really no need for me to dress up as a leprechaun or a crash test dummy or the Blues Brothers or something else. No, I'm not putting that on, so because I pretty much embarrassed myself on my own. But
well, you did get out of the Dallas.
And we had to have that one special made to fit his head. Oh, this is getting ugly. All right. And the second piece of this is, even if it's not a pre-tax salary reduction, an employer payment to an employee, and we've seen these types of arrangements for many years, and a payment from the employer to the employee on the guise that I'm going to reimburse you for a medical expense that you have not yet incurred and might not ever incur is also going to be taxable. And so you have to have an expense to cover the reimbursement.
Yeah, they're out there. I mean, and you all know the names of the programs. I won't mention any, Make Us Better, We the Best, and, We're Well, and, all these things. And those are made up names, hopefully not a real name. I don't want to be sued for, But there are a lot of bad programs out there. The IRS knows that they're out there. The IRS tried to address them in the regulations, those short-term limited duration regulations. They were convinced that there were enough good programs that outweighed, on balance, the bad programs. So you can expect, since they didn't have a regulation ruling out everything in the space, that they probably will hike up enforcement on the bad actors. So keep your eyes open in this space.
Yeah, and I skipped over a couple slides because John mentioned them earlier, and I know we've got a compliance topic session that's going to come up next. But I did want to bring up a matter that has really flew under the radar screen. So after Hurricane Helen, and what was the other one? Irene? Milton, yeah. It's hard to keep up with them anymore. Oh, is this a Chris Keller thing? Helene? Is that what it is? Yeah. Sorry. Wow, tough crowd. Anyway, the agencies, including the Department of Labor, issued guidance very much like the outbreak period guidance that delayed or suspended, I should say, it's a better way to put it, the same kind of time frames that we dealt with the outbreak period, claims and appeals, special enrollment, external review for major medical plans, but
Cobra periods.
all the Cobra stuff.
So keep in mind, I mean, this happens a lot. The fires, recent fires, I think in South Carolina, it's when there's a designation of a national disaster area, and the IRS keeps track of those areas. We've got the link there at the bottom of the page, I believe, Department of Labor link as well as the IRS link. Then they give some leeway with regard to participant deadlines as well as employer deadlines for things like filing 5500s or tax returns or what have you. We have pressed the IRS and said, if there is a disaster and somebody can't come up with an FSA receipt because there's a fire, because there's a flood, what have you, does this specifically apply to that? And, we got responses like, be reasonable. We're not going to give you guidance, but, if it is impacted, you document it. As a TPA, we're not necessarily going to blow up your plan because you accepted such documentation. So, keep your ear open. Flooded claim documentation from Asheville, North Carolina,
Oh, there's a bunch.
Los Angeles fires, what have you.
But it does affect the run-out periods in the same way that the outbreak periods
Yep.
did. It suspends that time period, and all that time period that was suspended then starts once this is over. And it's September, what was it, September? Wow, I can't
varied
remember
based upon
anything.
the disaster.
Yeah, but it will go till May 1st, and it also only applies in certain areas, and we've got links there to show you where those areas are.
Yep.
So here's the thing. From an administrative standpoint, what I think you have to do is if you're denying some claim or denying an action because it's untimely, I think you've got to hit the pause button, see if it's on the list of items that are affected by this, and then go and look at the areas and see if that person's in that area, and at that point, don't decline it for that. Trey, this first of all, are we going to be able to answer this, Trey?
Yeah.
Okay. All right.
I think so, but your prior slide mentioned that it was the entire states or maybe it's just tax.
It varies. It varies
yeah.
by disaster.
It's only all of Alabama, because like in Georgia, it's county by county, I believe. I just want to be clear, it is county by county most places, right?
Well, we've got Georgia on there, but I believe Georgia is county by county, and certainly Tennessee and Virginia are county by county. So
Yeah,
it's an
this is
area.
the difference between, I think, the IRS relief and some of the other relief. But
Yeah, that's tax year returns. It does vary based, because the IRS also had delays as well. So tax returns and anyone in all of the state of Georgia were delayed till May 1st of this year.
Yeah, so I think
Yeah.
this relief was county by county. For example, it was in Fulton, but
Yeah.
not in Cobb.
And I think we have that here in the Florida disaster areas of Georgia. So those are, and I was going to mention that, promise, no, I might not have, but the IRS guidance is a little different than the DOL guidance. DOL is a suspension of certain time frames, and really it's a push out of the due date on the IRS side for like tax returns and stuff. So it works a little differently, and it's applied a little differently.
also, I believe we have a Flex Reporter article, December article picked up on this.
Yeah.
It's in there as well.
Yeah.
Adjusted COLA amounts, keep in mind that those, of course, have been adjusted. We should sometime around May get the HSA adjustment, and then sometime after the August conference, because Kevin always complains about not being able to give it to us, the IRS adjustment will come out in October, probably, for FSAs and what have you.
You want to leave these four?
Yeah, with that, we've got, do we have a break until 4, or we go right into the technical advisory session?
Well, there wasn't a break.
And they
between
took one.
The last one in hours, and you took one anyway. So I think the punishment
You owe
is
us a break.
You can't have one now.
We can take a couple of questions and then do a very short break and start back at 4.
Mr. Spicoli, you owe me a
Yes.
break. Okay, there we go.
Can't do this. Questions, thoughts, comments, songs you'd like to sing?
Is this too much? It's always too much.
It's
But
not too much.
It gives you a lot of perspective with what employers are dealing with, because they are not FSA HRA centric. They're looking at the big picture. What do I need to cover? What's changing? What do I need to do on the healthcare side? HIPAA security, you're right. Yes, I need to do that. Big picture wise. So maybe it's not such a big deal to pull my cafeteria plan into that, my FSA plan into that. So, keep in mind when we talk about, HIPAA privacy, HIPAA security, your employers should not sit there dumbfounded. They should be doing something on the major medical side. The exception being, of course, the small, fully insured employer that has a self-funded FSA. But, questions? Yes. Bill.
Wait.
Yep.
Don't forget, we got to speak in the mic. We're recording.
And besides, I'm getting old and deaf, so,
On your HIPAA slide, which programs it applies to and which it doesn't, you said that LSAs that were medical, it did apply, and LSAs that were not medical, it didn't.
Correct.
Can you define what a health lifestyle account is?
Yeah, we've seen lifestyle accounts that provide medical benefits, and once you jump over that threshold,
Not really an LSA.
well, you're dealing with HIPAA, you're dealing with COBRA, you're dealing with other requirements as well. section, reimbursement substantiation rules. So you've got to be very careful there. And when we're looking at LSAs, we always recommend that you limit it to taxable items that are not medical. That, that's the best way to avoid it.
Yeah, because,
Uniforms, cafeteria, lunch reimbursement, things like that.
Because, Bill, you can call it a goose, but if it's a duck, it ultimately becomes a duck, right? So if you're reimbursing medical and you're capping the amount that you're reimbursing, you can call it an LSA all you like, but it's something else.
And that's a constant fight that we've been having
Yeah.
with some TPAs out there that will let anything in an LSA and say, well, it's after tax, so I can do it.
Yeah.
Well, you can do it, but do you want to deal with HIPAA, right? Yeah. Okay, good question. I wanted to make that clarification as that slide went by, but, I'm glad you kept us straight there.
Hey, one thing that nobody asked this, but I know one thing that we still see quite a bit of, less so than in the early days after, what was the Supreme Court decision on the reproductive rights? I can't remember anything these days.
Dobbs?
Yeah, Dobbs. Or HRAs that are reimbursing travel expenses. And early on it was to procure reproductive right services. We're seeing that more and more now for other types of services. And just keep in mind that there is a cap on the exclusion from income for lodging. It's prehistoric, frankly, because it's $50 a night for the participant and a medically necessary companion. And I don't even think that place that keeps the light on. What is that?
Yeah,
I
or
don't
if
remember
less
that.
of the Motel
Yeah.
6 rate.
Yeah, I don't think you can get that for $50, but that's the most that can be excluded from income for that particular benefit. Yeah. Oh, okay.
On the executive order requiring that within 90 days providers are providing actual costs,
Yeah.
wouldn't that require like real-time adjudication of a claim while you're standing in front of the provider's front office staff? To
Well,
be
for
able
the
to tell
trans-
you the actual price.
Well, for the transparency rule, on the provider side, for sure, yeah, it'd have to be, but it's also what they provide as information as well. So because the rules do seem to give some leeway for some estimates on certain things.
Yeah, which
so.
has been the big bugaboo for plans, is the providers can't get the data quickly enough.
Yeah.
But that's where it starts, and then I think it bubbles through to the plan requirements for the plan to show its benefits. Yep.
Yes.
On the manufacturer rebate or the reimbursement for deductible expenses on the high dollar drugs, I know, realizing that it's currently still in discussion and litigation. Worst case scenario, if they do determine that it is a disqualifying action for HSAs, what do you perceive as the disqualifying period?
Well, let me back up. I don't know that their determination at the end of the day would make it in and of itself disqualifying, because what the rule would be is that you have to apply it to the out-of-pocket max.
Okay.
So you'd have to do some serious gymnastics administratively, but you could carve that out of the deductible and still be okay. As far as the
So your health plan would have to have two counters, one for your deductible and one for your out-of-pocket.
yeah.
Nobody has right now.
And these drugs are so expensive that the manufacturer systems probably would eat up the out-of-pocket max really early on, if not in one month. And so then it would, you couldn't impose a deductible at that point. So you've got those administrative issues. But as far as the time period, are you concerned that it would be that they would do that retroactively, or?
Just, if there's this plan year, or, and as long as you're on the medication and receiving the.
We don't know. I couldn't even speculate a guess on how they might do that.
So you as ultimately, this hurts the participant. I mean, the employer doesn't have to have rebates in its program. Should the employer leave the rebate on the table? I mean, that's ultimately the argument that would need to be made. And
so there's one other too. So.
I'm not sure that the court would, side with the IRS that the HSA should be blown up. So there's a lot to go on this issue still. I know that IRS, HHS have been, visited on this issue, and I still think the final answer is not out there yet.
I get all
Go ahead.
excited when I want to say something. So there's one other piece of this that I didn't want to get into initially, but it's probably worth noting now that you've raised a question that touches on that. Most of the programs today, I won't mention them by name, but that administer this manufacturer assistance program, don't consider the drugs on their program to be essential health benefits. And only essential health benefits, the cost share for essential health benefits has to be applied to the out-of-pocket max. So if you stop there and said, okay, well, these drugs aren't essential health benefits, so we don't have to do that, it won't be an issue for HSAs. But the problem is there are two things going on. There's this rule about, well, do you have to apply it to the out-of-pocket max? And then how do you define an essential health benefit for purposes of these rules with regard to drugs? And the way that they have proposed to define it, have defined it for the insured market, not for the self-insured market, is basically every drug that a benchmark plan, really every drug in every class is going to be an essential health benefit. So it would almost be impossible to make that argument after this, if it ultimately ends up applying. So that was the other piece of this.
And kind of a practical response to your question, there's going to be some settling out period. I mean, the IRS is kind of beating their chest on the bully pulpit, and, we heard them, but everybody's just kind of frowning, and how are we going to do that? And I do think that if they stand firm, they are probably going to have to give some sort of leeway, hopefully prospective leeway on the rule.
Yeah, and let's keep in mind, too, and I'm going to use some of my southern vernacular here. Sorry, Chris. There ain't a single reg out on HSAs. It's all sub-regulatory guidance. And with the
And
demise of Chevron.
There won't be under the Trump administration. Right? They'd
No,
have
there
to
won't
pull
be.
back 10 other rigs.
You have to wonder how well those would withstand a challenge should that come to that.
As everyone comes back, I'm going to introduce Bill Sweetenham. Bill is our government and
Legislative and regulatory.
legislative and regulatory director. After many years, both on the Hill, and then Benefit Tax Council, which is like the decision-making group over at Treasury with regard to benefit issues. Bill Sweetenham has joined ECFC as our legislative and regulatory director. Under Bill, many of the regulations that define consumer-directed health care, everything from the HRA, the original HRA regs, which actually work, as opposed to the ICRA regs, which are kind of icky, came out under Bill, the HRA regs, the debit card ruling and regs. So a lot of what we're doing today is a product of Bill and Kevin Knopf and everybody.
All the HSA stuff?
All the
original-
HSA non-regulatory guidance, because they weren't able to get a reg out. But, and the proposed cafeteria plan reg that is now nigh on almost 20 years. We should have a
I
cake.
believe he was at Groom when that came out, weren't you?
But
2007.
Bill's going to give us an update on pending legislation affecting our space. So go ahead, Bill.
Okay. Well, thank you. Let's see if I can get this going. All right. I'm not sure whether I'm pressing the right things there. Nope. I guess I'm not. I'm not sure whether I'm doing the right things.
Do forward?
Nope.
Oh, wait a minute. We got.
Nope.
Okay. Well, thanks everybody for coming. This has
Right.
been good. I hope you
There
got
we
your
go.
questions answered.
All right. Well, this is
The
Well.
legislative environment is dark,
right. It was a dark and stormy night.
or dark and stormy drink.
Okay.
You guys are
What
not
am I
helping
doing
it out.
wrong?
You're just joking around.
Well, what I'm trying to do is
Here we go.
okay. 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 Does that do it? No. Which one? Which one? were
It's
you
the
using?
arrow. The arrow.
The arrow. There we go.
There you go.
Okay. All right. Here we go. All right. Well, what I'm trying to do today is to go over what are some of the bills that have been introduced either in this legislative session or in the last legislative session, or legislative proposals that are out there that we have to be thinking about and that we have to worry about. And some of these things we have in the materials that you're going to be have when we're doing our legislative sessions tomorrow. So you'll have some of this material tomorrow when you go on the Hill. So this is really just sort of to talk about what's out there, and so that you can sort of ask some questions, just to give you some general background, and also to give you a little bit of a warning about some of the other things that are out there that we may have to worry about. So the first thing is that John was talking about was the Telehealth Expansion Act of 2005. Remember, we thought we were going to have an extension of the safe harbor for telehealth at the end of 2004. That telehealth safe harbor ended at the end of 2004. We were all set to have that extended at the end of 2004. Mr. Musk sent 2024 sent out a tweet saying that he didn't like it, and that bill went down and it went away, and we didn't have. I think I sent probably about. I think I sent 3 Washington updates out to you guys, talking about how that thing, we thought it was going to happen and it didn't happen. Jody Arrington, who is the chairman of the Appropriations Committee in the House, has introduced a bill to make that telehealth safe harbor permanent. He has made it, if it passes, it would be retroactively effective. This Telehealth Expansion Act is not part of the continuing resolution that was passed in the House last night. It probably, it probably wouldn't be, because there was no tax provisions in that bill, and this is a tax provision. So it really has to jump on to some sort of a tax bill. But this is a bill. It's a bill that's out there, so the bill that's out there, if it gets picked up, it is going to be retroactively effective. So it's something that's out there, and it's one of the bills that we will be pushing. ECFC is one of the is part of a coalition that has been pushing the telehealth expansion, the safe harbor expansion. We've been sending letters in to leadership. So this is something. This is one of our big asks, and we're really on top of this. And so this is one of the things that you should be talking about when you're on the Hill. It's a big deal for all of us. And we have heard from people on the Hill that they haven't heard from people about this. That makes no sense at all, but it's something that we should talk about when we're on the Hill. So, and the good thing is that it's retroactively. We have legislation that is out there that has been introduced that makes it retroactively effective. Next thing, HSA Modernization Act. This is one bill that has a whole bunch of provisions that we like. The big thing is that we like is makes people that are covered by Medicare, covered by certain VA benefits, Indian Health Services, makes them all eligible for an HSA. We like that. That's one of the big things that we have in our asks, our legislative asks. Bronze and catastrophic plans would be considered to be HDHPs under the HSAs, pre-deductible medical mental health services of not more than $500, doesn't make somebody ineligible for an HDHP, fixes some of the, just fixes a bunch of things that we like. Some of the little problems that we all have with the HSAs, it fixes this. This is something that Representative Van Dyne has introduced. We have ECFs. We have talked to Representative Van Dyne, so we have supported this bill. We've made sure that she knows that ECFC is for it. But this is a bill that we very much have been supportive, particularly the first provision about Medicare, veterans benefits, and the Indian Health Services. That's been a big thing that we've been for on the HSA side. The Chronic Disease Flexible Coverage Act. That permits the HSAs to cover certain chronic health care services as preventive care. This codifies the guidance promulgated by the Trump administration in 2019. This was actually passed in the House on March 4th of 2024. Hasn't been picked up yet in the Senate. It's something that we have always been for. Again, it's one of those things that we were very much for because of the guidance. It's another thing that we always like to see this guidance to be made into law. So but it's something that has been passed in the House. We'd love to see it, get passed in the Senate. Here's one that the Oral Health Products Inclusion Act. This allows toothbrushes, water flosses, oral health care products such as toothpaste can be paid for or reimbursed by an HSA, FSA, or an HRA. It sort of follows the legislative language that was used for menstrual products. We weren't asked about this, but somebody Rachel had brought this one up to me. This was something that was that the Dental Association was pushing. Gee, amazing! The Dental Association was pushing to have dental products getting paid for by an HSA. We of course would be for this sort of stuff. Two things. We of course we weren't asked about this. No, but if anybody asked us, ECFC would say, oh, of course, we're always for products that could be could get paid for out of HSAs, and we also like it when products can be paid for out of HSAs in an easily administratable manner. And we now know that this is the way that we can the way that it was done with the menstrual products is a very easy way for them to get certain expenses to be considered to be paid for out of HSAs, FSAs, and HRAs. So they can do it easily. They now know how to draft it, and they can draft it in a 2-page bill. So two things here. One, I think John was talking about it, is, well, what if we start getting with a new Make America Healthy again, uh, uh, efforts. Oh, gee, I want good milk, raw milk, to be paid for out of your HSA. Well, you can't do it under current law because it's not a qualified medical expense. But if they wanted to do it, they could follow the way that they did it under this Oral Health Products Inclusion Act and follow that, and just rather than having toothbrushes, water flosses, oral health care products, put raw milk. Okay.
Isn't that milking the system, though? I mean,
There we go.
But to some extent, and this is a policy issue, it's much bigger than this group and us, but to some extent, if everything that makes you alive is tax deductible, what's the cost on that?
That's the thing is that here's why probably ECFC is probably not the proper lobbying organization to go in and say, gee, we think that you should have this sort of stuff be considered to be a qualified medical expense. But because we're not the people that will sit there and tell them, oh, milk is the right thing, but the dental people are able to make a wonderful thing about the toothpaste and water flosses and oral health care, that these are important things to do. So they're the ones that sort of push this sort of stuff. Another issue that when we're talking about this sort of thing, and it's important when we're talking about lobbying and our thoughts about legislation, is that when we look at this sort of stuff, we also look to see whether these sorts of things are administrable to you folks. This Oral Health Products Inclusion Act is administrable to you. There has also been out there a bill about gym equipment. And there's a bill about gym equipment, but the bill about gym equipment puts a dollar limitation on it. And the dollar limitation is generally is not administrable to you guys. So when we find out, when people call and ask, what does ECFC think about the gym equipment bill, I tell them that, gee, we don't like that bill because it's not administrable to our folks. So let's say that we have a raw milk bill. But the raw milk bill says raw milk can be a qualified medical expense up to 2 quarts a week. I will say ECFC doesn't particularly care for that, because I don't think that you would want to be able to, find out whether it's 2 quarts a week to do your administration. So that's, just sort of, we get a lot of, I get a lot of calls, and we get calls, and people talk to us about these sorts of bills, and so this is sort of the what we sort of think about when we hear about these sort of things. Number one, is it administrable? And they call me. They call me. I read it. I take a look at it. I call up Sarah and say, "Oh my God, looks what's going on now," and then these are the sorts of things that we see. So, just wanted to bring that up. Start off with one bill and then just sort of, give you sort of a good idea about what we think about this sort of thing. Next one, Primary Care Enhancement Act. Well, generally primary care, direct primary care arrangements, what they're trying to do here is trying to figure out how direct primary care arrangements can be managed within an HSA. And the major thing that you have to do is you have to define what a direct primary care arrangement is, and then sort of work around whether it can be allowed in the arrangement and whether the HSA can be used to pay for the premiums for such a direct primary care arrangement. This bill, these bills which were introduced last year by Smucker in the House and Cassidy in the Senate, set out what is a direct primary care arrangement, and they defined a direct primary care arrangement. It put a monthly dollar limit on what the premium payments would be to participate in the arrangement, and they put a limit on what sort of services could be provided under a direct primary care arrangement. Interesting to know, Representative Chip Roy has a direct primary care bill out there, and his bill has eliminated the dollar limit on direct primary care arrangements. We'll talk a little bit more about Representative Chip Roy later.
We call that an HMO, don't we?
Well, we call what Representative Roy wants to do a lot. He's changing things a lot.
But if it's Smuckers, it's got to be good.
Oh, geez, John. Yeah, I know. Yeah. Okay. Well then, but that's another one, and we've generally been for these direct primary care enhancement acts. Lowering costs for caregivers act allows you to use HSA and FSAs to pay for medical expenses of both parents and spouses of the individuals that own that have the HSAs and the FSAs, rather than just dependents. And we find that's fine. The choice arrangement that codifies the ICRA guidance, and that was something that Sage was talking about the other day. And the choice arrangement is something that they really would like to do. The ICRA guidance is something that was a big thing with the Trump administration. The unfortunate thing is that the choice arrangement, it's very difficult. The choice arrangement, the ICRA guidance, having it move in a budget reconciliation bill would be difficult because since it's just codifying current guidance, it doesn't have budgetary costs, so it can't move under a budget reconciliation bill. So while they'd like to see that this move, it might be very difficult to move it under a budget reconciliation bill. Here's one that we really like a lot, and we talk a lot with Representative Shire, Improving Child Care for Working Families Act, and that increases the exclusion for dependent care assistance FSA plans from $5,000 to $10,500. That was included that was introduced last year. We'd like to see whether she includes it this year. Unfortunately, Representative Shire is a Democrat. Who knows whether Democrats get anything done this year? However, this is something that does help working families. So it could be, something that if they ever decide to be bipartisan in helping working families, this could move, this could move on some respect. But Representative Shire, they call us, all the time when these things move, and they find us to be very helpful. And they think that ECFC, if they're going to move, if they're going to reintroduce the bill, they will call us, and we will support this bill. So here's some potential bills of concern. Remember, one of the things and Sage talked about it, is the fact that they've got to do the budget and do all of the tax stuff and try to get all of the tax bills done with the dollar limits that they have. And one of the things that they have to do is there's not enough under the budget reconciliation authority that they have, is that they may not have enough budget reconciliation authority to get all of the tax proposals that they want, one being extend the Trump Tax Cut and Jobs Act, and then they've got the other provisions like the no tax on tips, no tax on overtime, no tax on bonuses, no tax on Social Security. There's going to have to be, there's not enough under the budget reconciliation to do all of that sort of stuff. So there's going to have to be some tax increases in order to offset those tax decreases, or other budget increases. And Sage was talking about. So let's talk about some of the other issues that are out there that may try to try to raise revenue or change revenue and deal with some of our issues. One is Representative Roy's Healthcare Freedom Act. Representative Roy's Healthcare Freedom Act changes HSAs, and HSAs under this bill would be renamed Health Freedom Accounts. Health Freedom Accounts could be used to pay for costs associated with direct primary care, health sharing ministries, medical cost sharing arrangements. Contribution limits would be increased to $12,000 yearly. Catch-up contributions would be increased. So it's going to increase all of that, but it's going to sort of change the tax treatment of other types of employer-provided health insurance. The tax, remember the way that taxes, with regard to taxes on, we have a tax exclusion for employer-provided health expenses. What Representative Roy's bill does is for any employees that are hired 5 years after the effective date, is that they will no longer be able to have an employer exclusion for any employer-provided health insurance other than contributions to a health freedom account. So what they're doing is they're moving all employer health coverage into the employer healthcare freedom accounts. So, for example, a cafeteria plan, for those cafeteria plans won't work for anybody that is hired 5 years after the tax exclusion.
Or FSAs, or
Or
HRAs.
HRAs, right.
Or dental, I mean.
And anything.
Big employers just would not, I mean, this is just kind of deal with dead on arrival, right? I mean,
Well, we would like to think that it's dead on arrival. However, Representative Roy is sort of, and the other people that have that are co-sponsors of this plan are the very conservative members of the Republican Freedom Caucus, and in order to get them to vote for the bill last night, who knows what they got? And in order, because they don't vote for these budget bills. So we're wondering whether this bill could be, out there. And it also, years ago I worked for an oil company. This would present a two-tiered system of employee benefits depending on when you were hired. It just doesn't make any sense.
Although I like the health freedom account part because it would, Microsoft spell check would no longer change HSA.
Yeah. Well,
We were on a roll.
yes. So this is, so this is one of those things, it expands HSAs, but it's something that we, this is something that I'm going to be watching like a hawk to see whether this thing moves or not. Another one that we have to worry about is USA accounts. Now, here, one of the things is that the House Budget Committee set out a whole bunch of potential revenue raisers in a 60-page document. And I went through this 60-page document and was worried about some of the revenue raisers. Well, here are some of the revenue raisers that could impact us. USA accounts. This option, and I'll just read it here, this option would replace health savings accounts with a universal savings account indexed to inflation, and it would be a Roth-style account. So it wouldn't be, you wouldn't get the deduction going in, but distributions from it would be tax-free, and they would be used for anything. So it would just sort of change our world immensely. So distributions would not have to be made for qualified medical expenses. No requirement for a high deductible health plan. So this would be, but again, this would raise a lot of money because you would eliminate the initial upfront deduction that you currently have for people's contributions into an HSA or into, so it would, that raises money in the short run in order to pay for all of the other tax things that they want to do under the budget reconciliation bill. Next, eliminate transit benefits. What that would do, the employer-provided transportation benefits like transit passes and parking are currently excluded from taxable income. It would eliminate the tax exclusion for that, so you wouldn't be able to have those anymore. So that would, again, that would generate revenue. You wouldn't be able to, so.
I don't see that one moving.
Oh, geez.
Ashley, have you been giving him lessons?
No,
Yeah.
this
You're
is
the funny one.
Another one, eliminate tax-free on-site gyms. I mean, so on-site gyms would become taxable. I think the last thing is that employer-provided health care is the largest tax expenditure, and so that if you're searching for revenue, you always look to what is the highest, what is your biggest tax expenditure. Employer-provided health care is your biggest tax expenditure. And that's, so we always have to keep our eye out and make sure that, our industry is based off of the tax exclusion for employer-provided health care. And so we have to keep our eye on that. And, as they look to try to find the revenue in order to make sure that they can fund all of these tax cuts that they want to find, we have to keep our eye out on it. So that.
And Bill, that's kind of what was behind the Cadillac tax, and we, of course, realized the impact of that. So, and there are bigger coalitions and umbrellas that work on preserving employer-provided tax advantage of employer-provided health care. So
Right.
you plug in with those and work with those and continue.
Yeah. So.
With that, we're going to turn it over to Chris and Katie from Groom. Groom is a very heavy contributor for our Flex Advisory Committee and the Flex Reporter, and they're going to give us some more detail on that litigation.
I didn't get any. No one clapped.
Well, you kind of ended on a sad note.
I wouldn't clap either. I would like boo me. I'd boo me off the stage.
And employer, Chris, Katie, go ahead.
Well, let's see if we can figure this out. Uh-oh.
I think they already previewed us, Katie. So there was a little bit of a teaser, apparently, before we came in. So John had teed it up that we're going to talk about this topic. We already did it.
You went through the slides?
They kept asking for the slides. I should have known why.
Did you say the breaking news from Monday? Did you talk about the breaking news? Wow,
They didn't
there you
really
go. Well, so there's been a couple cases in the health plan space, and we were a little worried about this in the retirement plan space. There are certain plaintiffs' attorneys that go out and file basically these cookie cutter lawsuits saying that there's breaches of fiduciary duties for too high of fees in the retirement plan space. We saw this with Cobra, the same handful of law firms just filing lawsuits saying the Cobra notice that someone, class action lawsuits that the person didn't elect Cobra because the font size was an 11-point font instead of 12-point font. I mean, just crazy things. So these same plaintiffs' attorneys are now turning their sights to health plans, and they filed a couple suits with respect to, and it's kind of complicated, but the general gist is that they're saying that the contract between the PBM and the employer caused the plan, and in turn the plan participants, to pay too much for prescription drugs. And in fact, more than they would have to pay if they just went off the street and went to the pharmacy themselves. And one case is this Johnson & Johnson case. We've been watching this very closely, and in January, the court granted the motion to dismiss that Johnson & Johnson filed, basically saying the plaintiff didn't have standing. And that's because the plaintiff didn't show any harm. By the time the plaintiff tried to fill her prescription for the drugs, she had actually already met the out-of-pocket maximum under the plan. So the court said, you don't have any standing, you didn't show any kind of injury, you personally didn't actually pay anything more than you would have paid. So they dismissed the complaint. And we were a little worried because it seemed like the court laid out a roadmap for the plaintiff's attorney on the next case to find a plaintiff that actually didn't meet the out-of-pocket maximum and therefore did have standing. And that's exactly what happened. So on Monday, that's the late breaking news. On Monday, the plaintiff's attorney filed a revised complaint and tweaked a couple arguments with respect to this plaintiff, but also added a new plaintiff. And the new plaintiff had not met the out-of-pocket maximum already. But with respect to the original plaintiff, the attorney said, well, yes, maybe she met her out-of-pocket maximum, but it doesn't matter if she did or did not, she still had to pay, even, say she hadn't met her out-of-pocket maximum, she would have had to pay more for the drugs, and she would have had that cash to go buy a car or do something else. So it did negatively impact her. So that was filed just on Monday. Obviously, we don't have any kind of decision on that yet. But we are a little concerned now that the court has laid out kind of a roadmap for someone to have standing. And then there's also this case, which is the Wells Fargo litigation, which is basically the same lawsuit. It's brought by the same attorneys. They added a couple of prohibited transaction arguments, but it's essentially the same lawsuit. So, keep a lookout. We are probably going to keep seeing more and more of these lawsuits filed. And Chris is going to talk about, best practices with vendors of how to try to protect yourself against these lawsuits.
Yeah. Thanks, Katie. So yes, I think when the original Johnson & Johnson got dismissed, everyone said, do we not have to worry at all about this anymore? But our phone really was ringing off the hook, as I'm sure Ashley's and John's was, regarding individuals who were sitting on fiduciary committees at their employer locations and saying, we don't really do all that much. We have consultants, we talk to outside counsel when we need to, but for the most part, don't health plans just kind of run themselves? There's a very heavy reliance on vendors. And so I think this was a wake-up call, and our advice is, even though the first Johnson & Johnson complaint was dismissed, now we know we have the second one, but really let's learn from what happened to both Wells Fargo and having to deal with this lawsuit, and then also Johnson & Johnson, who again now has to deal with it. So there's just a couple best practices that we have been talking with all of our clients about. And so if you are an employer, you should listen with that hat on. And if you're a service provider, you should understand that your clients are thinking about these things and try to make it maybe easier for them to satisfy these requirements. So one key requirement is to put out a request for proposal, and that would allow an employer to essentially receive a lot of information about not just one, but multiple vendors. They could hire an expert to help advise, what are the pros and the cons, because choosing a vendor, which is reinforced in both of these decisions, is actually a fiduciary decision. So designing a plan is not. Designing a plan is what the employer does, and that's a set law decision, but choosing a vendor is a fiduciary decision. And sometimes, I think, unlike on the retirement plan side, the health and welfare folks just aren't necessarily in that process. They don't always, or hadn't before these cases necessarily, ironed out who was doing what. A lot of it gets delegated down, which is fine, but if there's a committee, that committee should be receiving information. So one would be doing the RFP, maintaining records. Sometimes it's just an individual within a company that has this responsibility, and then it's a little more challenging, although they could write notes to the file about why they made certain decisions. If there's a committee, that's easy. They can take notes. There can be minutes. The minutes should be pretty high level, but they should, generally cover what was discussed at the meeting, and that is what you'll use to defend a lawsuit if you get sued. Why did you pick this person? Well, here's our minutes, and this is the reason why. And then using experts to help you evaluate the different proposals, especially if you're talking about, as these cases were, the PBM area, that is hugely complicated. So you would need someone to help you navigate, how do PBMs usually work? How are things set up? Is one contract better than the other? How do the rebates all work? So really what it's about isn't really even making the right decision at the end of the day. It's just about showing that you followed a process in choosing the vendor. And that process, as I just mentioned, it's identifying the information, reviewing cost, reviewing quality, looking at more than one vendor. Even if, let's say you are in this business and you want to pick yourself, and we get that call sometimes, we really don't ever want to use anyone besides our own company. Do we have to do an RFP? And the answer is, ideally, you would collect the information and ask the people who are on the committee not to be thinking in employer terms, but to be thinking in terms of what's best for the plan participant. And then you can still pick yourself, but it would be nice if periodically you had some documentation explaining why you made that decision. Utilize your experts. You might have actuaries, consultants, lawyers, and when they give you advice, you either need to follow that advice, or if you don't like the advice, find a different expert to give you different advice. It's never recommended to get a nice report from an expert and say, yeah, this is great, but we're going to do this whole other thing. That's exactly what a plaintiff's lawyer would be looking for evidence that you actually did not follow a prudent process. And then you want to document the decision. So you're not done after you choose your vendor, then you have to contract with your vendor. So Katie, do you want to talk about that?
I hadn't planned on it, but I will.
I'm trying to split it up.
Let me see what the slide says. Yeah, I think the main thing is just the disclosure of compensation. So in the contract, you want to disclose if there's compensation that's being paid to the vendor. If the vendor can, especially in the PBM contracts, there's lots of compensation. The PBM is usually not only the administrator of the benefit, but they're also the pharmacy, and so they're getting compensation from a lot of different sources. If there's going to be float interest that's being earned, that the vendor's going to be earning, make sure that the contract discloses all of that, so that it can show that all of that was taken into account in the contract.
Perfect. And then last, on vendor monitoring, so you picked your vendor, you contracted with your vendor, and I think in many cases the fiduciaries would like to just say, okay, we're done with that for another 3 or 5 years. We don't have to worry about it. But really, there is also this obligation under ERISA that you're going to monitor your vendor. And we've had a lot of clients come to us in the wake of these lawsuits saying, what exactly does that mean? What specifically are we supposed to do? And we have a lot of vendors, by the way, so this is going to take a lot of time. Do we really have to do it? And our advice is yes. Unfortunately, you do need a formal process. So if your committee is meeting regularly, put on the agenda that you're going to review. If you have 10 vendors, sort of split it up throughout the year. Get a report and, try to figure out, are our participants happy with this vendor? Have we had any service issues? If we have we addressed them? Is the vendor receptive to addressing them? And again, this doesn't have to be the committee members themselves. If it's a big company, they've got lots of other things to do. They can delegate to someone else, but that person within the company they've delegated to should periodically be reporting to the committee what's happening. So participant surveys are sometimes really helpful because you can learn information about what the vendor's doing. I know for some of our clients, they handle eligibility appeals internally, so they may delegate an administrator to do the first level of appeal, but if there's a second level, they may take a look at that, and that's a really helpful way to understand if there's a gap in the process or any kind of ongoing issue. Maybe there's some mistake that's being made in the system and you can fix that. So all of this, again, like I said, it's about process. It's not being perfect. It's just making sure there's documentation in the form of minutes or other reports showing that you're monitoring and staying on top of what's happening. So yeah, and then when the people who are doing the monitoring are, you know, engaged in that process, they have to remember I'm acting as a fiduciary. I'm thinking about the plan participants. I should not be thinking about the company when I'm doing that work. But after we turned in our slides, we did have another issue that we thought of that we could talk about. It's sort of a surprise issue. Surprise! So I'm going to turn it over to Katie for the big reveal. One more time.
Yeah, so we were just thinking, you know, what are topics that are coming up a lot with our clients that you guys would care about? And I think the one thing, just today I got like 4 phone calls about GLP-1 drugs. And, you know, a lot of it, especially if you're non-calendar year plans, but even calendar year plans recently, getting their data back from last year and their drug spend, and they're way over budget because of the GLP-1 drugs. And the plans have covered them, you know, always covered them. There's people who've been taking these drugs for years. It's just now that they're shown for weight loss, more people are taking them, and the costs are just skyrocketing. So, you know, lots of employers are looking for ways, how are we going to manage these costs? What are we going to do? And there's been every idea under the sun. There's different programs that vendors have for weight management, or even some that you have to wear a continuous glucose monitor, continuously giving information back to this vendor. They're tracking your weight, lots of tracking going on. And so whenever there's tracking about your body happening, we have to think about the Americans with Disabilities Act, because that prohibits an employer from making disability-related inquiries or medical exams. And so if there's someone's continuously tracking glucose, is that a medical exam? But there's also HIPAA non-discrimination, because a lot of employers, maybe they say for diabetics, we're going to let them continue taking the drugs, but we're worried about the weight loss people. That's really where the costs have skyrocketed. I think they've skyrocketed with the diabetics too, but so they might want to make some distinctions and say, well, what if we have these programs for weight loss, obese people, but not for the diabetics? Is that discriminating based on a health status, and we need to worry about HIPAA? So there's lots of rules we need to think about with these programs. And we actually did have an employer client that an employee complained to the EEOC, filed a complaint. We drafted up our best argument for why this was okay, and they ended up, the EEOC did not take any action with that. But
it was a complaint because they were requiring this biometric.
Yeah, they had to wear the continuous glucose monitor, and they basically couldn't get coverage for the drug at all unless they participated in this program. And, you know, they were calling the employer Big Brother and all of these things. But the EEOC ended up not doing anything. They had a DOL complaint as well, and DOL did not do anything either. But, you know, you can imagine these employees are not happy because, you know, these drugs are very expensive that they have to pay out of pocket. So one idea that we've seen recently come up is, what if the plan excludes the benefits, the drug altogether? And a lot of times it is for the weight loss, obesity, or, you know, if you're overweight with certain health conditions. But the plan would exclude the drug altogether, and then the employer would create on the side an HRA that just paid for these drugs. And that way they could cap the cost, they know what their exposure would be, and maybe they would say, okay, we'll pay up to $5,000 a year for these drugs, but that's it. And then they know that, you know, there's a certain level of exposure out there. So that's just one thing. I've seen that idea come up a lot in the past, I would say just month or so. So I think that is one way that employers are looking to maybe try to manage these costs, is just to use account-based plans as a way to manage the costs and not cover them under the health plan anymore. But I don't know, Chris, if you've seen that too.
And I think I've seen some surveys recently that show that employers that are covering these drugs are really, really interested in continuing to cover them if they can come up with a way to try to make sure that the drugs are being used in the right way and that they're working, and also, honestly, just to cut down the number of people using them. So I do think some of the programs that Katie mentioned out there, they're sort of on the right track as far as, you know, we want you to be accountable, maybe we want you to check in with us, or we want to have some discussions. So I do think there's a middle ground that employers will probably, you'll hear probably more about that this year, where you can't just sign up and get the drug maybe. You have to actually do a couple of other things in order to receive it, including maybe talking with someone about health or logging exercise, but it has to stop short, in our opinion, and I'd be curious what John and Ashley think. I'm sure you guys have worked on this. It strikes us that it has to necessarily be something that doesn't collect this biometric data. Is that me? Or
Yeah.
Oh, I turned everything off, I swear.
Yeah.
Fat
Big
chance
Brother
if you
is
think we're going
calling.
to a lawsuit. But I think it is an evolving area. We see a lot, and, it just reminds me a lot of the early wellness programs. I mean, you just think about it, you get up in the middle of the evening, and we actually, 15 years ago, had an employer that wanted to hook up a monitor to a scale in the employee's house. And so you can imagine, John, yes, you gained 5 pounds. Well, it was the chicken. Well, no, it wasn't the chicken. It was the chocolate cake and the beer that you had with the chicken. I mean, we can think of the issues and the privacy issues and the HIPAA issues, and, it's just incredible how many faults that you could step into trying to regulate that, where a plaintiff attorney could sue.
Yeah, and also, yeah.
And your EEOC, I mean, we've had smoking cessation cases where the EEOC said no charge, but we still have plaintiff attorneys that bring suit. And
And I think clients get lulled into thinking, well, we're doing a good thing for our participants, but you've heard the phrase, the road to hell is paved with good intentions, and I think that really.
Or no good deed goes unpunished.
I like that one. Could be either one.
Yep. Well, couple of things. In the slide deck is, kind of our top 10 list, Ashley and I, from our presentation, for HSAs, FSAs, HRAs. We'll drill down more on that in August, and we'll use that as one of our August discussion points, departure points, maybe a workshop on it. So we want to make sure that that in the deck that will be available from Crystal, those slides are in there, and so you've got that. We don't want to set our agenda back any further today, so we're not going to pick those up, but I want to make sure you still have those, and we'll cover them in August. But we do have time for maybe 1 or 2 or 3 questions, either questions about the legislation. We'll get the microphones around. I don't know if one of these needs to be passed around. Questions about the legislation, questions about the fiduciary claims and RFP issues, or any of the topics today. And I see one over here and one over there. And we'll go ahead. Question. I can't see where the mic is. But it's over here.
So the question on the HRAs for the excluded drugs from the formulary, I've seen those too, where they'll carve out the drug, but usually where there's an international or some sort of a manufacturer rebate program. So my question is, if that happens and they don't get approved for the manufacturer's rebate program, and then they have to pay for it through the HRA, does that cause problems? And maybe John or Ashley, as you talked about, with HRAs, and does that cause any problems legally for the HRA?
I see an HSA HDHP issue. If you also have an HSA and you're carving out and providing first dollar
You
coverage.
could do it post-deductible.
I know,
Yes.
but first dollar, if you're doing it first dollar. There are also potential MAPIA issues if you're offering a weight loss drug but not a mental health treatment on a parity basis. So I think it's something that could be considered, but there are some compliance issues that you've got to look through.
Keep in mind, these programs that you're leaning on to cover the cost of the drug, often condition their participation on there being no underlying coverage.
Yes.
And so you have to be careful. So, I mean, the ones we've seen, there's not been an HRA underlying that. It's just been, we're going to carve it out and we'll submit it. And if it's not picked up by the whoever, the third party, will pay for it outside the plan.
But even that could be underlying coverage, and you could have an issue with the drug manufacturer rebate company suing, and there's some pretty nasty lawsuits over that. I think maybe J&J might have been involved in one case, but yeah.
No,
I think there was another case recently. It wasn't J&J. It was, I'm not blanking on the name, but with the employer, with that
Yeah.
program.
Yep, you gotta be very careful with those programs, and, yep.
Yeah, you got ERISA plan asset issues, because I mean, I don't know how you do it. If the plan says, oh, well, we don't cover that, and you end up covering it with participant contributions, then you've got ERISA plan asset issues, you've got tax issues. If you say, hey, it's not covered, you cover it, don't include it in income.
Yeah, I think the path maybe that we'll see will be maybe similar to what we've seen with some fertility benefits. So we've seen employers maybe that historically haven't covered fertility, and then they create an HRA, they have a vendor to manage that. Yeah. I anticipate it would probably work that way. I think it would be hard for the employer to do completely on their own without having a vendor in charge of that, but I predict we'll probably see that a little bit more this year.
So, question over here, go ahead.
So, Section 125 has a prohibition on using a salary reduction election to purchase coverage on the exchange, which I've always believed is poorly written because I think it was intended to prevent double dipping. And, you know, you can get coverage on the exchange without getting the subsidy. If a bill were to be proposed to amend that provision to either clarify that it's prohibited to purchase subsidized coverage, or a carve out for purchase of coverage using employer-sponsored ICRA dollars, would that bill be able to be paired with the ICRA codification and then perhaps be passed in budget reconciliation?
Bill, do you want to answer?
Yeah.
Say yes.
Well,
But only if it's yes.
I would have to be, it would really, I'd have to see what the dollar, what the Joint Committee on Taxation said the budget impact would be, because the budget rules are that it has to have a substantial impact. It can't have I can't remember the exact wording. It can't have just an ancillary impact, budgetary impact. It has to have the provision has to have a true budgetary impact in order for it to be considered under budget reconciliation. And so what you would have to do would be you have to go to the parliamentarian, the budget, and the parliamentarian would make a decision as to whether it would
Yeah,
meet the.
it's probably neutral anyway, because if you're making the salary reduction to go on the exchange to buy something that costs more than your ICRA contribution, you're not eligible for the tax credit anyway, so I don't know, but I'm just looking for a way to get that, both of those things accomplished.
From a reconciliation standpoint, but I think, as we think back in 2010, believe it or not, they did not want to dismantle the employer group market too quickly. And there was a fear that if employers could buy coverage in the individual market, it would overwhelm the individual market. And that's some of the reason we have that language, and you can't use employer dollars through an HRA or directly or through a cafeteria plan to pay for individual coverage.
But now you can.
Now you can, if you have an ICRA that pays for part of the coverage, you can pay for the rest through a cafeteria plan.
Right.
A supplemental cafeteria plan, but not directly. Yeah, I think you can.
We've got participants who are using the salary reduction and going into the individual market. They just can't purchase the same plan on the exchange. And there are a few carriers who only offer coverage on the exchange that they like better because it has a better network, or maybe it's a lower cost plan, but it's still unsubsidized. So to me, that's just one of the ICRA friction challenges. That's.
Ooh, I like that. We should have like an ICRA friction thing night.
I'd like to do that with this group.
Let's do that.
The vision that paints in my mind is just icky. The ICRA friction challenge. Okay. Next question. Any other questions? In the back is a question.
Thank you. I don't recall seeing a point of view on the Hope account, and another large publicly traded company expressed in their last review that they are eyeing it and they might be bullish on it. Curious for your thoughts on the potential for that in this administration. I'm glad, and I did. There you go.
Hope sells. Hope floats. I don't have it.
Yeah, I guess where I've been, what I was looking at was what was being pushed by the budget committee, and the Hope account wasn't being pushed by the budget committee. Really, the budget committee staff was pushing the USA accounts. So, I mean, so so
Bill?
close. I mean.
So Bill's saying his presentation was hopeless, but you were early in the legislative process,
right.
and it could still make its way in.
Yeah, but I mean, what I, the budget committee, was sort of putting out, they had 62 pages worth of stuff that they were trying to do in order to reduce the budget and to get revenue, and Hope wasn't in. The Hope accounts weren't in there, but USA was, so.
But it's the same
Yeah,
concept.
it's
the same genre.
Yeah, similar concept.
And I'm sorry, same is a bad word. Similar concept. So I mean, to the extent that the USA account has legs, the Hope account sponsors may glom together and blend some kind of legislation that comes out. How's that for legalese for you?
Well, it's
So do we have?
the thing is that what I'm more worried about is that Chip Roy has a little bit more sway in this, because he and his crew, are a vote, have a decisive vote in this, and that's where I sort of, and he's sort of he's promoting this health freedom account, which is similar but not similar. It has the, he has the he's deductible going in, but he then kills any other deductions, any other employer provided health deductions. So, so they're both, everybody's trying to sort of gain revenue by getting rid of some sort of employer deduction for health insurance expenses. They're going at it in different ways.
Okay. Our next session is the meet your groups. We want to thank our panel, our technical advisory group panel.